The question I'm answering today really is a combination of estate planning and Medicaid planning, which we do a lot of throughout the state of Florida. The question is why you want what's called a testamentary special needs trust built into your last will and testament. I know a lot of interesting concepts there. Let's break them down. First, I think we all know what a last will and testament, but essentially it is where you write down in front of two witnesses and a notary explaining who you want to get your stuff after you pass away. You relying on a last will and testament means you go to probate court. Now, even if you want to avoid probate, you're still going to get what's called a pour-over will with your estate plan, right? If you have a revocable living trust because you want to avoid probate at all costs, you're going to have any estate planning attorney is going to have you sign a last will and testament, which essentially says, if I forget to put something into my trust, throw it in there, okay? So everyone needs a last will and testament. However, there is a situation where we want your assets being ejected from your revocable living trust and put back into your estate so that your last will and testament can deal with it in court. Why? I thought court was a four-letter word. Aren't we doing everything we can to avoid court? The answer is yes, but there's one situation where we absolutely want it, and here it is. If you are married, this only applies to a legally married couple in the state of Florida. If you have one spouse passes away and they are survived by a spouse who would benefit or who is already receiving Medicaid long-term care benefits, in that case, we cannot rely on a trust because a trust is available to either spouse. And typically the trust says if the first spouse passes away, whatever's left over is for the benefit of the second spouse. Well, we don't want that if one of them needs or is on Medicaid at the time, because inheriting that money is going to throw them off of their Medicaid long-term care benefits, which can help pay for home health care, assisted living facility care, nursing home care. So instead, we build in a toggle. If we're working with a trust, the toggle says, if at the time of the first spouse's passing, the successor trustee believes that it would be in the surviving spouse's best interest to be on Medicaid or is on Medicaid, we want to protect it. In that case, we're going to eject assets out of the trust. We're going to put it into the deceased spouse's estate, and we're going to have their will say what happens. Because the will, if it's done correctly, if you have one of these testamentary special needs trusts built into it, which must be there, then a judge can order, instead of the assets going to the surviving spouse directly, it can go into this testamentary special needs trust. The law is very specific in that this cannot happen through a revocable trust. It has to be a part of the will. It has to go through the probate process. It has to be court ordered by a probate judge, which is why this is the one scenario where you're going to go, yes, I want the probate, because otherwise my loved one is going to have to not going to be able to qualify for these long-term care benefits that can be immensely valuable. So the testamentary special needs trust is built into the will so that anything in that trust, the state of the Florida statutes say anything in the testamentary special needs trust is not counted against the surviving spouse when determining whether or not they're eligible for Medicaid. When you're dealing with children, you can rely on a revocable trust and have a separate type of special needs trust built into that. But when you're talking about spouses, you have to rely on the will. There's really no other way. There's no other way, but this is a very common way of dealing with that. So for that reason, whether you're doing your estate planning with our firm or another firm, make sure you ask the question, hey, is there a testamentary special needs trust built into my last will and testament? Because you want the answer to be yes. Hope this answers the question. Hope you found this video valuable. If you did, please give it a thumbs up. Please share it. Please subscribe to the channel. And I appreciate you watching, and I hope it's been helpful.